In a golden statue, Lady Justice is blindfolded. In one hand she holds a balanced scale, and in the other hand she holds a sword tucked under her arm. Figure 11. One Lady Justice is traditionally shown wearing a blindfold to indicate impartiality, holding scales to weigh the evidence of guilt against the presumption of innocence, and wielding a sword as a symbol of power. Credit: Golden Lady Justice, Bruges, Belgium, by Emmanuel Heibrecht/Flickr, CC by 20. Chapter outline. 11.1 What is the judiciary? 11.2 How does the judiciary take action? 11.3 Types of legal systems around the world. 11.4 Criminal versus civil laws. 11.5 Due process and judicial fairness. 11.6 Judicial review versus executive sovereignty. On May 25, 2020, Minneapolis police officers stopped George Floyd, a black man, for allegedly using counterfeit money. During his arrest, one of the officers, Derek Chauvin, knelt on Mr. Floyd's neck for more than 9 minutes while the other officers looked on, leading to Mr. Floyd's death. Several people witnessed the event, including one person who recorded it on her phone, and these witnesses immediately spoke out against the officer's actions. The death of Mr. Floyd prompted demonstrations protesting police conduct to spread across the United States and worldwide, with protesters demanding immediate action against the officers. However, it was the Minnesota judicial system that would determine the legality of the officers' conduct and whether and how they would be punished. Like all others in the United States, this judicial system must follow a constitutionally ordained process in every case, no matter how people may feel about the parties involved. Following these constitutionally required procedures, Minnesota law enforcement investigated George Floyd's arrest and death, and prosecutors with the Minnesota State Attorney General's office prosecuted Chauvin for 3 crimes: degree murder, second-degree murder, and second-degree manslaughter. News sources reported on the pretrial process, and the trial was carried live on television. 2. Throughout the trial process, viewers saw the order, procedures, and vocabulary of the United States judicial system at work. Many people have less personal, everyday experience with the courts than they have with the legislative and executive branches of government. The court system uses a specialized vocabulary that can be intimidating until you learn it, but understanding a country's court system is central to understanding how that country's government and society work. This chapter will discuss court systems and their processes to help you understand the operations of judicial systems and their purpose in society. Learning outcomes. By the end of this section, you will be able to distinguish between rule of law and rule by law, identify the responsibilities of a judicial system, compare and contrast the different methods states and countries use to select judicial officers, discuss major criticisms of each method of judicial selection. In Chapter 4, Civil Liberties, you learned that law is a body of rules of conduct with binding legal force and effect that is prescribed, recognized, and enforced by a controlling authority. In the world today, that authority is usually the government of a particular area. However, multiple levels of government may have authority in a given place. The power of a governmental body to exercise the highest authority in an area is called sovereignty. If a government has sovereignty over a particular region, that government can create and impose rules on people within the region. Chapter 4, Civil Liberties, also introduced the rule of law, the principle that the government is beholden to its laws, not to any individual or group. Throughout history, many individuals and small groups have become dictators with the sole power to create laws and punish people as they wished, thus employing rule by law. There are still some dictators in the world today, as in North Korea. Dictatorships are oppressive and dictatorial regimes are prone to corruption. By following the rule of law, robust democracies try to avoid these injustices. Video. Court Shorts, Rule of Law. In this brief video, United States judges who preside over different types and levels of courts discuss the meaning of the rule of law and the role it plays in our everyday lives. Recall the 4 principles of the rule of law. Accountability. The government and private actors are accountable under the law. No one is above the law, just laws. The laws are clear, publicized, stable, and applied evenly, and they protect fundamental rights, including the security of persons and property and certain core human rights. Open government. The processes by which the laws are enacted, administered, and enforced are accessible, fair, and efficient. Accessible and impartial dispute resolution. Justice is delivered in a timely manner by competent, ethical, independent, and neutral decision-makers who have adequate resources and reflect the communities they serve. These principles demonstrate that the government and the people are in a social contract, a voluntary agreement whereby the people consent to abide by specific rules while living in the territory, and the government consents to limit itself to acting in accordance with certain standards. This creates a symbiotic relationship between the government and the people, rather than a system based on fear and oppression. In each democratic country, a constitution sets up the framework for government operations that adhere to these four principles. The constitution formalizes how the country's government will wield authority and implement powers under that authority. The constitution may be written or unwritten in one document or several, entitled Constitution or Basic Laws. Whatever its form or title, a constitution establishes the basic government structure for the government's sovereign territory. It usually creates branches with differing powers that have the ability to check each other in the exercise of those powers. One of the branches that carries out the rule of law in a country is the judicial branch. The judicial system or judicial branch is the court system that interprets, defends, and applies the law in the government's name. It is the mechanism for peacefully resolving disputes between individuals. Sometimes people refer to this branch of government as the judiciary, but that can be confusing because the judiciary also refers to the people who work in the judicial branch. Therefore, this chapter will consistently refer to the branch of government as the judicial branch and the people who work in that branch as the judiciary. The judicial branch serves different purposes in different political systems. For example, in a political system that prioritizes civil rights and liberties, the judiciary working within the judicial branch checks government action and protects individual rights and liberties. In a system in which there is a separation of powers between the branches of government, the judiciary has judicial independence. In these systems, often the courts can perform a judicial review to check government actions. In judicial review, a judge interprets and implements the Constitution to ensure that the other branches of government do not violate what it says. Judicial review will be explored later in this chapter. In contrast, some political systems rely on adherence to strict religious or political standards, creating authoritarian law regimes. In these systems, the judicial branch and the judiciary help impose the government's approved viewpoint on the citizens through rule by law. In these systems, the judiciary has little independence. The judicial system acts as a source of government control over individual citizens. Tom Ginsburg and Tamir Mustafa identify 5 primary functions of courts in these authoritarian rule-by-law regimes: to establish social control and sideline political opponents, to bolster a regime's claim to legal legitimacy, to strengthen administrative compliance within the state's own bureaucratic machinery and solve coordination problems among competing factions within the regime, to facilitate trade and investment, to implement controversial policies so as to allow political distance from core elements of the regime. 4. Video. Justice handed over to dictatorship from the film Judgment at Nuremberg. The 1961 film Judgment at Nuremberg portrays the military tribunal at which 4 German judges who served while the Nazis were in power faced charges of crimes against humanity. In this clip, the former Minister of Justice explains changes in the judiciary under the dictatorship of the Third Reich. In rule-by-law authoritarian regimes, the government suppresses opposition and imposes a specific viewpoint on any part of the government or the population to the extent that human rights violations occur. 5. Iran and North Korea are examples of rule-by-law authoritarian regimes. The dictatorial leader of North Korea is selected to a lifetime appointment on a state-approved ballot where only one candidate is listed. This leader has control over the judiciary and all must adhere to the leader's will or face retribution. 6. Other countries have come to have an authoritarian populist judiciary. This means that through changes instituted by one ruling person or political party, they have transitioned from a rule-of-law system to a rule-by-law authoritarian subsystem. In Turkey, longtime President Recep Tayyip Erdogan and his ruling party replaced the governmental system in 2017 and have enacted laws to keep themselves in power. Changes in 2007, 2010, and 2017 gave Erdogan and his ruling party the ability to appoint and dismiss prosecutors and judges, thus calling into question the independence of the judiciary. 7. A European Commission report in 2020 found that the continued centralization of power in the president was blurring the lines of separation of powers in the branches of government such that few checks and balances remain. Under these conditions, the serious backsliding of the respect for democratic standards, the rule of law, and fundamental freedoms continued. 8. The report identified significant issues with the Turkish judicial system and its slide into rule by law, not the rule of law. Turkey's judicial system is at an early stage of preparation, and serious backsliding continued during the reporting period. Concerns remained, in particular over the systemic lack of independence of the judiciary. The president announced the judicial reform strategy for 2019-2023 in May 2019. However, it falls short of addressing key shortcomings regarding the independence of the judiciary. No measures were announced to remedy the concerns identified by the Council of Europe's Venice Commission and in the European Commission's annual country reports. There are concerns that dismissals in the absence of respect for due procedures caused self-censorship and intimidation within the judiciary. No measures were taken to change the structure of and process for the selection of members of the Council of Judges and Prosecutors to strengthen its independence. Concerns regarding the lack of objective, merit-based, uniform, and pre-established criteria for recruiting and promoting judges and prosecutors persisted. No changes were made to the institution of criminal judges of peace, so that concerns regarding their jurisdiction and practice remained. 9. One can thus see the difference between the rule of law and rule by law. Each judicial system can be assessed on the basis of how well it meets the rule of law criteria for protecting the rights of the people from government overreach, manipulation, and the rise of dictatorships. How the judicial branch differs from the other branches of government. Judicial branches differ from the executive and legislative branches because, unlike in those branches, the judicial system restricts how the courts may act and how the people may express their opinions to the courts. A good description of this restriction appears in Federalist No. 78, wherein Alexander Hamilton wrote about the judicial branch as it is described in the U.S. Constitution. Whoever attentively considers the different departments of power must perceive that, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution. Because it will be least in a capacity to annoy or injure them, the executive not only dispenses the honors but also holds the sword of the community. The legislature not only commands the purse but also prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. 10. In rule of law systems, the judicial branch depends on the other branches and the population's respect for the rule of law to carry out its decisions. An example helps illustrate the differences between the branches and their powers. In the United States, a president alarmed at the number of gun shootings occurring in the country can create a commission to review the problem and make recommendations to Congress to enact new laws. The president, the executive, can implement some of these recommendations by executive order, a particular type of binding law that only the chief executive can create. The people can express their views on the subject to the president at any time. Congress, the legislature, may also be alarmed about the number of gun killings. They can open an investigation and create a statute to limit some access to guns. Again, the people can express their views on this subject to Congress at any time. In both examples, government officials decide what they want to investigate and what actions they want to take, and the people can freely voice their opinions on the subject. Courts, however, cannot take action on their own in the ways the executive and legislative branches can, and people cannot express their opinion in court unless they meet particular criteria. A court can only take action if it has jurisdiction over a specific case. Jurisdiction is the written authority, stated in a constitution or a statute, that authorizes a court to hear a case. Jurisdiction includes both the geographical region and the topics of the court's authority. What can I do? Critical thinking and the courts. 3 rows of judges sit at long tables in front of Soviet, British, American, and French flags, examining numerous sheets of paper. Figure 11. 2. The judges at the International Military Tribunal at Nuremberg critically examine evidence and testimony. Credit. View from above of the judges' bench at the International Military Tribunal in Nuremberg by United States Holocaust Memorial Museum, courtesy of National Archives and Records Administration, College Park, public domain. Every functioning government must have a functioning judicial system. As you study the different forms of judicial systems, how they operate, and elements such as the standards of evidence across different judicial systems, as well as different types of law, you are sharpening your critical thinking skills. Being able to understand and explain why someone is found innocent of a particular crime, for example, requires the ability to analyze, evaluate, and synthesize various pieces of information coming from the defense attorney, the prosecutor, the facts of the case, and the components of the law in question. This is the core of critical thinking, and it is a fundamental skill that is utilized in virtually any career. Critical thinking skills are highly valued, and they take work and practice to develop. Studying topics such as courts and judiciary systems is a good way not only to prepare for a career within the legal world, as an attorney, for example, but also to hone general critical thinking skills that are invaluable regardless of what direction your professional path in life takes. Selecting judicial officers. There are as many ways to select judicial officers as there are countries in the world. The particulars of the selection process vary widely by country. The selection process can also differ for different levels or types of courts within a country. All of the selection processes can be sorted into 4 broad categories. Appointment for life. Appointment for a specified number of years. Election. Hybrid or a combination of these methods, e.g., appointment followed by retention election. Lifetime appointments. The U.S. Constitution establishes a Supreme Court of the United States, SCOTUS, and authorizes Congress to create other Article III courts. 11. The judges for these courts are nominated by the President and confirmed by the U.S. Senate. These Article III judges serve for life as long as they remain on good behavior. There is no mandatory retirement age. These courts have the power of judicial review and, once appointed, are independent of the other branches of government. Congress can change any court's jurisdiction except SCOTUS's original jurisdiction. Still, neither Congress nor the President can fire a judge nor stop the judge's salary if they disagree with a decision the judge makes. Thus, the judiciary in the United States has some measure of independence, but judges are often subject to political pressure during the appointment process. Article III courts include the United States Supreme Court, U.S. Circuit Courts of Appeals, and U.S. District Courts. There is only one SCOTUS, but there are 13 Circuit Courts of Appeals and about 100 District Courts. All have multiple judges, so the power to appoint judges is a substantial one. Moreover, because these judges are appointed for life, a president can influence the interpretation of the law and the Constitution well beyond that president's term of office. As noted by legal scholar Alexander Bickel, you shoot an arrow into a far distant future when you appoint a U.S. federal justice, and not the man himself can tell you what he will think about some of the problems that he will face. 12. The changing political landscape. Women on high courts around the world. While gender representation on high court benches across the globe skews toward men, studies suggest that the rate of women on judiciaries in countries around the world rose by about 29% between 2011 and 2019. Research suggests that a high court judge's gender may be a better predictor of how they will decide a case than their political leanings, and that the gender composition of a court can influence how individual judges view a case. 13. Video. Ethiopia's first female Supreme Court Chief Justice, Misa Ashanafi. In this clip, Misa Ashanafi, the first ever female Chief Justice on Ethiopia's Supreme Court, talks about how she worked to define sexual harassment and violence against women in the Amharic language, the official language of Ethiopia. She goes on to discuss the importance of the impartiality of the courts and the role courts play in serving their communities. The lifetime appointment of judges outside the United States is rare. Even in countries that say they appoint certain judges to lifetime terms, these judges are held to a mandatory retirement age. 14. For example, in the United Kingdom, Supreme Court justices are not subject to term limits, but they must retire by age 70. 15. Additionally, in the United Kingdom, there are minimum requirements for nomination, and a nominating commission reviews applicants. Finally, this type of appointment applies only to a particular court, not to all courts in a broad category, as in the United States. In Belgium, the monarch appoints constitutional court judges from a list of candidates submitted by Parliament. 16. As in the UK, these judges are appointed for life with mandatory retirement at age 70. The monarch selects judges for the Supreme Court, the Court of Cassation, from candidates submitted by the High Council of Justice, an independent 44-member body consisting of both judicial and non-judicial members. Like constitutional court judges, Court of Cassation judges are appointed for life with a mandatory retirement age of 70. 17. Recent discussions in the United States have debated instating a mandatory retirement age or setting a term limit for Article III judges. 18. Appointment for a term of years. There is a second type of U.S. federal judge, those appointed for a term of years. Congress, in creating these courts, specifies the qualifications of the judge and the term of service. 19 potential judges apply for the office as one would apply for any other job. A hiring committee selects the judge. Several U.S. states also appoint some of their judges for a term of years. The process for an appointment varies by state. 20. Many countries appoint some of their judges for a term of years, though the processes by which they do so differ. 21. For example, in Albania, the president alone makes some 9-year appointments. 22. On the other hand, the Chinese legislature, the People's National Congress, appoints the Chief Justice of their national Supreme Court for a limit of 2 consecutive 5-year terms. 23. To be considered for most judicial appointments in France, an attorney must pass a series of entrance examinations. 24. They must then attend special classes and pass a series of difficult examinations to be eligible for an appointment as a judge. The Ministry of Justice oversees this process without any executive input, appointment by election. A few U.S. states use a rare process, election, to select some judges. In a 1988 speech, Hans Lind, a former justice of the Oregon Supreme Court, said to the rest of the world, "American adherence to judicial elections is as incomprehensible as our rejection of the metric system." 25. When judges are directly elected, the judiciary is an agent of the government with limited independence. The voters use their votes to pass judgment on judicial decisions in the same way that they use their votes to weigh in on the actions of the executive and legislative branches. Thus, one of the criticisms of judicial elections is that they incentivize judges to make politically popular decisions that are not necessarily correct interpretations of the law. Different U.S. states employ different types of judicial elections. A candidate's political party is listed on the ballot in partisan elections, while the candidate's political affiliation is not listed in nonpartisan elections. Many states have moved away from direct elections and toward retention elections. In a retention election, a judge is appointed for a term of years, and at the end of that term, an election is held to determine if the judge should be retained for another term or replaced. 26. Texas is one of the few states that still holds partisan elections for almost all judgeships in the state. 27. As a result, candidates run for office just like all other elected officials. They align with a political party, receive the majority vote in the party's primary election, and campaign showing their affiliation to the party. Most other states have moved away from this selection style because of issues with partisanship, such as the appearance of impropriety when someone makes a large campaign contribution before appearing before the court, and the instability of a process that selects candidates based on political popularity rather than legal expertise. 28. Texas has been the object of scrutiny for allegations of favoritism to campaign donors and political party influence on judges. 29. As a result, there is pressure from a number of corners, including former and current judges, to change this system. 30. About 13 states still hold nonpartisan elections for some of their judgeships. These states assert that this enables people to have a say in the judiciary while removing political partisanship from the selection process. 31. Video. Former Chief Justice of the Texas Supreme Court Wallace Jefferson on electing judges in Texas. In this clip, former Chief Justice of the Texas Supreme Court Wallace Jefferson weighs in on how he believes the state of Texas should select judges. Switzerland also holds judicial elections in which the Federal Assembly, their legislative branch, elects judges to 6-year terms. 32 A few other countries also hold some judicial elections. Hybrid or mixed selection. Many countries have a hybrid system, with a mix of appointments for term and appointments for life depending on the type of court. 33 A couple of countries and a few U.S. states have both appointments and elections. One common hybrid selection system used in several countries is an appointment with review after one term. In Japan, the Chief Justice of the Supreme Court is designated by the cabinet and appointed by the monarch, while associate justices are appointed by the cabinet and confirmed by the monarch. All justices are subject to a popular referendum at the first general election after their appointment and every 10 years thereafter. 34. Several U.S. states use a hybrid system known as retention or the Missouri Plan. This system has gained popularity in the United States over the last 50 years. 35. In a retention system, the executive initially appoints a judge with legislative approval, similar to the federal appointment process. The appointed person serves for a term of years. After this initial term, if a judge wants to remain in office, they must run in a retention election. There is no opposing candidate in a retention election. People vote on whether to keep or replace the judge. The judge runs on their record, and their party affiliation typically is not listed on the ballot. A retained judge remains in office for another term. In some states, there is a limit to the number of retention terms a judge may serve. If the judge is not retained, then the process starts again with new nominees and appointments. This style appeals to many Americans because it limits campaigning and political party influence over the judiciary while allowing the people some say over the judicial officers. Learning outcomes. By the end of this section, you will be able to discuss the way the judiciary works with other branches of government, analyze the power of the judiciary to act, analyze the constraints on judicial action. A court cannot implement its decisions. The other branches have to turn the court's decisions into written statutes or orders. You cannot go to court to challenge a law just because you disagree with it. You can complain to the legislature or speak out in public, but if it's a law the government enforces, a criminal law, you must wait until you are charged with violating that law to complain about it to a court. If a statute gives you the right to make a claim against another person, neither you nor the person you are claiming against can challenge the law until one of you has filed a lawsuit against the other in court. Once a charge or a claim is brought before the court, the people directly affected by the application of the law now have standing, or a direct injury from the effect of the law, to complain about the law before the court in a court case. A court case is a specific dispute about the law and its effect on the parties or the people directly affected. The court can only consider specific questions brought by the parties, and these are called issues. The court can only determine if the facts, that is, the evidence, meet the criteria specified in the written law and answer the questions the parties have raised. Let's look at a couple of examples. Each of these concepts will be explored in more detail later in this chapter. Suppose the government enacts a law prohibiting someone from protesting outside a city hall and makes a violation of that law punishable as a crime. A person may not like this restriction and can complain to the legislature, seeking to change the law. However, the person cannot complain in court at this time. If a person does protest outside City Hall and is arrested by the police for violating the anti-protest law, and if the government charges that person by filing a criminal case, then that person can challenge their arrest and the law in court. The government will try to prove that the person should be punished because their actions violate the law as written. In certain systems, a person can also complain that the law is an infringement on their right to free speech and protest, and can seek judicial review of the law to have it declared unconstitutional and ultimately struck. Another example is a civil case in which two private parties seek the court's assistance in deciding a dispute. For example, say you are driving down the road and another car hits yours. Both parties in the accident feel the other driver is at fault and should be responsible for the expenses of having both vehicles repaired. You can try to resolve the problem between yourselves. However, if you want a court to assist you in deciding the issue, there must be a statute or a written law enacted by the legislature that allows you to file a case in court against each other. The court can only apply the law as written to the facts, the evidence of what happened, in making a decision binding on the two of you. If there is no law on the books relevant to your dispute, the court cannot help you. Implementation and impact of judicial decisions. Judicial implementation is the process by which a court's decision or judgment is put into practice and enforced. However, in almost all countries, the courts rely on the executive branch to implement their decisions. A court can issue a judgment or legal order, but it does not have the power to compel government personnel to carry out or enforce its orders. The executive branch, which carries out daily government operations, is the branch tasked with implementing judgments. Thus, unless other parts of the government recognize the force of the court's decision, the court is powerless to put its orders into practice. The implementation of desegregation orders in the United States in the 1950s and 1960s is an excellent example of the executive enforcing the court's judgment. In these cases, the federal government, including the president, vigorously enforced the Supreme Court's orders for school desegregation, calling out National Guard troops to escort students to school. 36. The court's most significant power to enforce its decision lies in the people's acceptance of the rule of law. Suppose the people do not respect the judicial system or its authority. In that case, the executive branch must physically enforce the judiciary's orders, which may cause a public backlash against the government. Again, the court's desegregation order in the Brown v. Board of Education 1954 decision serves as an example. Even years after the decision was issued, many states and school districts refused to follow the order. This resulted in further litigation and the interventions of Presidents John F. Kennedy and Lyndon B. Johnson to enforce the court's decision. Local politicians and the American public continued to put obstacles in the way of integration for many years. Public resistance can almost always defeat court-ordered action unless the executive and legislative branches back up the court's decision. Black students walked down the stairs at the entrance to a building, holding books in their arms, escorted by uniformed military personnel wearing combat helmets. Figure 11.3 By order of the state governor, the Arkansas National Guard prevented 9 black students from entering Central High School in Little Rock, Arkansas on September 4, 1957. Credit: Arkansas National Guard at Little Rock Central High School, Little Rock Central High School, National Historic Site, 1957 by U.S. National Park Service, public domain. On September 4, 1957, the governor of Arkansas ordered the Arkansas National Guard to prevent 9 black students from entering Central High School in Little Rock, Arkansas, in defiance of the Supreme Court ruling in Brown v. Board of Education 37. Eventually, on September 24, President Dwight D. Eisenhower sent in nearly 1,000 U.S. Army troops to ensure order and enforce the desegregation order from the court. 38. At other times, presidents and state governors have refused to obey court orders. These refusals have resulted in many disputes and, at times, nullification of the court's decisions. Because the courts cannot implement their own decisions, when a government refuses to obey a court order or statute, that government effectively nullifies the court's decision and the law. A typical example of nullification in the United States today is the federal reaction to individual states legalizing the use of marijuana. Federal law prohibits all growing, selling, and possession of marijuana throughout the United States, and SCOTUS has affirmed this complete prohibition over a state's attempt to legalize medical marijuana. 39. However, even with the federal law and SCOTUS decision, many states are legalizing the sale and use of marijuana. The federal government and courts could enforce the federal law against these states. However, they have chosen not to do so. Instead, the federal government allows state governments to regulate marijuana growth and use within their states, focusing instead on interstate and international drug trafficking. Thus, the federal government itself is actively engaging in the nullification of the law. Whether or not you support this action regarding marijuana, think about the possibility of nullification in other contexts, such as federal laws prohibiting racial and sex discrimination. What if a state decided to nullify these laws within its borders? Would you support nullification in this example? Nullification damages the rule of law. if states and individuals decide independently that they do not have to obey a law, without following the processes designed to ensure that no one is above the law, then the rule of law itself is weakened. Many argue that a better way to change a law one does not like is to urge the legislature to change it while still respecting the system of government and the rule of law. The legislative branch can counter a court decision by changing a law the people do not like. The legislative branch can enact a new law that changes the one on which a court based its decision, or it can even propose amendments to the Constitution to achieve the desired result. Take the example of the federal income tax. The Supreme Court initially held that Congress's statutory enactment of a federal income tax was unconstitutional. In reaction, Congress proposed an amendment to the Constitution to permit a federal income tax, and the states approved the amendment. This action succeeded in making the federal income tax constitutional and defeating the court ruling, all within the framework of the system, all while respecting the rule of law. 41. Major court decisions may also influence social reform. People can look to court decisions as steps toward desired social reforms and use them to gain public support or change the law incrementally. Again, the Brown v. Board of Education decision provides a practical example. Before Brown, a series of court decisions held that different types of segregation in education were unconstitutional. These decisions narrowed the court's holding that separate but equal accommodations were acceptable in the area of education. By the time Brown was decided, the law was primed to abandon segregated education entirely. However, some parts of society were not acting on the reform and challenged the laws for many years, leading to discussions about the judicial branch's role in making public policy. Can courts make public policy? There is no one answer to the question of whether and how courts make public policy. Courts do not openly make public policy as they only answer questions presented to them in a specific case by interpreting written laws. They cannot look at global events and decide to take action as the legislative and executive branches can. However, by the impact of their decisions, courts can impact law and society, thus nudging social and political policies in a particular direction. Once again, consider the Brown decision. In Brown, the Supreme Court held that in K-12 education, separate is inherently unequal and ordered the integration of K-12 public schools. That was as far as the Brown decision went, as that was the only question before the court. However, the decision influenced many people to begin questioning segregation in other areas of society, and public officials started to question their role in enforcing segregation laws. This social influence of judicial decisions is often seen as a beacon of hope by those seeking more comprehensive changes in society. It can bring attention to an issue that may have been at the margins of the majority's conscience. After Brown, the nascent civil rights movement gained momentum. This momentum led to Congress enacting the Civil Rights Act of 1964 and the Voting Rights Act of 1965. States also enacted civil and voting rights laws, and numerous individuals openly challenged segregation laws by breaking them and fighting against their constitutionality in court. This extrajudicial influence is not a direct path. There are debates about how much impact judicial decisions have on social movements. There was already a civil rights movement long before Brown, but without the activists who filed the Brown lawsuit, there would have been no decision to invigorate it. Whatever the effect of the court's decision on the momentum of the civil rights movement, it is clear that a significant court decision that is perceived as a policy-making decision impacts society by bringing the issue to the attention of more people and causing many to think about the issue in a new way. Thus, courts can make policy for society through their decisions when interpreting laws and the Constitution. 42. Learning outcomes. By the end of this section, you will be able to describe the different types of legal systems and explain how they differ. Explain how the rule of law applies in different judicial systems. Analyze how different judicial systems operate. There are 5 basic types of legal systems in the world. They are civil law, common law, customary law, religious law, and hybrid or mixed systems. Today, mixed or hybrid systems are common. Because each system varies by country, this chapter will focus on the characteristic traits of each kind of system. A world map shows the distribution of 5 basic types of legal systems. Much of Europe, South and Central America, and parts of Asia have civil law systems. North America, Australia, and parts of Asia and Africa have common law systems. Islamic law systems are found primarily in Northern Africa and the Middle East. A few countries, primarily in Asia and Africa, have customary law systems. Several countries, mostly in Asia, Africa, and the Middle East, have mixed systems. Figure 11 for this map shows the different types of legal systems in place around the world. 43. Attribution. Copyright Rice University OpenStax under CC by 4. 0 license. Note that before discussing different law systems, it is important to distinguish between what the term civil means in the context of legal systems and what it means in terms of civil versus criminal laws. Common law systems. The U.S. legal system and other legal systems that emanate from British rule is a common law system. 44. Originally, common law meant judge-made law that filled in gaps when there was no written law. Judges looked to prior decisions to determine the unwritten judge-made law and apply it to new cases. However, today, almost all law is in writing and enacted by a legislature as statutes. Many statutes codify established common law, change it, or abolish it altogether, depending on the topic of the law. There are instances in which some unwritten common law is still enforced, but these are rare. In a common law system such as the one in the United States, the court's reliance on precedent is referred to as stare decisis, or a policy of using judicial decisions made in the past to interpret written laws and appropriately apply those laws to the facts in the present case. 45. The court interprets written laws, and these interpretations and applications of precedent from prior interpretations constitute what is meant by common law today. Precedent is critical for interpreting later cases, and only the same or a higher court can overturn precedent. The court process is adversarial rather than investigatory, with each side trying to win or persuade the court to agree with its perspective. 46. Video. What is precedent? This video discusses precedent and its importance in common law systems. Common law courts are adversarial, that is, there is a winner-takes-all attitude in the court. In an adversarial system, each side determines the issues and questions it wants the court to resolve, conducts its own investigation, and prepares and presents its own evidence. Each side calls witnesses who are questioned directly and by cross-examination. Each side brings out information it thinks is pertinent to prove its point. In a criminal case, the police and prosecutor work together closely to establish their viewpoint using the government's resources. Defendants must rely on their own resources to defend against the charges, either hiring an attorney or using a court-appointed one. In a civil case, the procedures are similar. However, each side must rely on its resources to prove its point. If a jury is present, it decides all factual questions while the judge determines the legal issues and moderates the proceedings. In some cases, the judge can act as a fact-finder in place of a jury. Civil law systems. Most of Europe and South America use a civil law system. 47. A civil law system relies on comprehensive legal codes that contain all laws for the country. Case law, that is, judicial decisions, is secondary to these codes. Decisions are binding only on the parties to the case, not as a precedent for later cases on the same issues. While attorneys will consult prior decisions when advising clients, judges are rarely bound to follow precedent. For this reason, codes of statutes are usually more extensive and detailed than in common law systems. In civil law systems, court cases are investigations by the court to see how the facts fit into the already established codes applicable to the situation. The court system is set up so that the jurisdiction of each court is a specific type of code. Tax courts, administrative courts, maritime courts, constitutional courts, and so on. The system is more inquisitorial than adversarial. The process is a series of meetings, hearings, and written communications in which the judge takes testimony. The judge crafts the issues to be decided based on discussions with the parties. Typically, the judge questions the witnesses and can include or exclude any queries submitted by the attorneys when crafting questions. Finally, the judge determines the issues and gathers the evidence before announcing a decision. 48. Only at the final hearing do the attorneys and parties make arguments to the judge. If there is a jury, its members usually are not drawn from the general public but are selected for their expertise in the particular area in question. While juries of ordinary people are rare in civil law systems, they are increasingly used in serious criminal cases. These two systems, common law and civil law systems, are the most widely used legal systems in the world. They differ in terms of the weight they give to judicial precedent and their views on the purpose of the trial process. Religious systems. In a religious law system, the law relies on religious texts as its primary basis, and the courts interpret the present facts and statutes in light of those religious texts. Many Middle Eastern countries use religious law systems for all or part of their laws. 49, for example, in Saudi Arabia, the legal system is based on Sharia law derived from the Quran, the Islamic religious text, as well as from the Sunnah and the Hadith. 50, the legislature enacts statutes, but all are tested against Islamic tenets. Certain religious leaders can overrule any government act, including court decisions, on religious grounds. The legal system includes general and summary Sharia courts with some administrative tribunals for specific topics. Religious law systems do not use juries, and criminal trials do not present defensive evidence to the same extent as in other legal systems. Each judge, a specialist in the religious Sharia text, makes their interpretation of the law and is not bound by any precedent. Israel also uses some religious laws and courts to determine cases. 51, for example, religious courts in Israel include Jewish rabbinical courts, Islamic Sharia courts, Druze religious courts, and ecclesiastical courts of the 10 recognized Christian communities. In Israel, these courts are limited to some specific issues of family law. The secular court system decides all other matters. Customary systems. A customary law system is a system based on long-standing traditions in a particular community. The traditions have become so ingrained in society that the courts recognize them as enforceable rules. However, it is rare for customary laws to be interpreted and enforced by the government. Instead, select leaders of the group usually implement the customary laws. As a result, customary laws are typically unwritten and revealed only to group members. Today, customary laws are found in closed, isolated communities combined with common or civil law systems, allowing them to exist alongside government systems in a hybrid system. Andorra, a small country in the Pyrenees bordering Spain and France, relies partly on customary law. In Andorra, sources of customary law include canon law, the ecclesiastical law of the Catholic Church, Castilian law, French law, and Roman law. Andorra was invaded and under the control of other European powers at different times in its history, and the Andorran legal system now reflects elements of each invader's laws. Today, Andorra is a parliamentary co-principality between the President of France and the Roman Catholic Bishop of Catalonia, Urgell. Andorra also has an elected parliament that can enact new laws. 52. Common law, civil law, religious law, customary law. Other names: judge-made law, Anglo-American law, continental law, European law, Roman law differs by religion. Two prominent ones are Sharia, Islamic law, and Halakha, Jewish law differs by area, ethnicity, and tribe. Source of law: case law and statutes, which may be organized in codes, statutes organized in codes, religious texts, long-standing customs, which may be oral or written. Degree of judicial independence high. Important to society that judiciary appears to be independent of executive and legislature high. Important to society that judiciary appears to be independent of executive and legislature wide range, from very limited to high, wide range, from limited to high. Judges wide variety of selection and qualification standards, career position requiring training and testing. Civil servants' religious and legal training varies widely with customs of the area. Policy-making role due to stare decisis shares power with individuals who come before the court and with government branches. Equal but separate power as the enforcer of codes depends on territory and topic area. Paramount in some cases, advisory only in others depends on territory and topic area. Paramount in some cases, advisory only in others. Examples: US except Louisiana, UK, Canada except Quebec, all European Union countries, Quebec, Louisiana, Saudi Arabia, Iran, United Arab Emirates, Israel, Guernsey, and Table 11. 1 Differences among major legal systems. The island of Guernsey is another example of a customary law system. Though it is one of the Channel Islands off the coast of England, Guernsey is not part of the United Kingdom. Guernsey's legal system is derived from the medieval power of the monarch, the Duke of Normandy. 53. The ancient Duchy law of Normandy is an influential source of law in Guernsey. The duchy laws developed in two periods, the ancient Caudum of 1199–1538 and the Caudum Reformé of 1538–1804. 54. Guernsey's legal system also has elements of English common law and modern statutory law enacted by the island's elected legislature. Guernsey enjoys almost complete autonomy over its internal affairs, and the country determines many issues based on ancient customary laws, with elected bailiffs and jurats making decisions. 55. In the United States, some customary laws may be used in tribal matters on tribal lands recognized by the U.S. government. 56. However, the U.S. government does exercise some control over tribal legal systems in the United States. There is a growing worldwide movement to recognize tribal autonomy and customary legal systems. 57. For example, some Maori customary law is now recognized in New Zealand. 58. Hybrid or mixed systems. A hybrid legal system combines parts of more than one approach to create a system unique to the country. Many countries have mixed legal systems incorporating common, civil, religious, and customary law systems. 59. For example, the U.S. state of Louisiana has a hybrid system. Louisiana uses some common law, but it also utilizes a civil law system for much of its state law and procedures because of its origins as a French territory. Also, on recognized tribal lands, customary laws of the tribe may be used rather than state or federal laws. Another example is the Philippine system, which includes French civil law, U.S.-style common law, Sharia law, and indigenous customary law due to its history. 60. Many African countries include a parallel tribal or ethnic legal system to adjudicate family law matters. 61. A map shows the various types of legal systems present in the different parts of Africa. While different types of legal systems are used in different countries throughout Africa, every country except for Angola uses a mixed system. Figure 11. 5. This map shows the different types of legal systems present in Africa. Attribution, copyright Rice University, OpenStax under CC by 40 license. Learning outcomes. By the end of this section, you will be able to differentiate between criminal and civil laws, discuss the purposes of criminal laws, discuss the types of criminal laws, discuss the rights of the accused in criminal proceedings in different systems, discuss the use of the death penalty in different systems. Within a given legal system, there are two major types of law, criminal and civil. Criminal law applies to offenses against the state. The action is punished because it harms society. Criminal law requires a statute to create the offense, its elements, and its punishment. An act is not a crime unless a written law establishes it as one. Only the government can prosecute a criminal case. A criminal case begins with an alleged crime, an arrest by the police, and a charge filed by a prosecutor. Anything that is not criminal law falls under civil law, which applies when one individual is harmed by another and seeks compensation for the harm. In civil law legal systems, civil offenses are only by statute. In common law legal systems, civil offenses can be by statute or case precedent. 62. The overarching purpose of criminal laws is to protect society as a whole. There are 5 general purposes of criminal punishment. Incapacitation, punishment removes the offending person from society, inhibiting their ability to cause further harm to society. Retribution, the punishment of the individual is said to satisfy the public's desire for revenge. Deterrence. Punishing a person for committing an offense is intended to deter others from committing that same offense. Restitution. Punishment for a criminal offense may involve a financial penalty to compensate the victim of the crime monetarily. Rehabilitation. Punishment may attempt to refocus the offender's energy on a more acceptable pursuit to prevent recidivism. Recidivism is the repetition of a crime by an individual already found guilty of and punished for the crime. 63. Many countries have moved to a focus on rehabilitation as a means of stopping future crime. 64. The use of rehabilitation is common in Europe, especially for nonviolent or drug offenses. 65. The U.S. state of Oregon is enacting similar policies to rehabilitate those who are found guilty of illegal drug use. 66. A figure shows the purposes beyond deterrence and retribution that different types of punishments are intended to serve. Mandatory counseling and treatment center placement are intended to rehabilitate. Incarceration, the death penalty, or house arrest are intended to incapacitate, and fines are intended to require the person being punished to provide restitution for what they have done. Figure 11.6. While all punishments are intended to serve as deterrence and retribution, many common punishments are intended to serve other purposes as well. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. There are two main types of offenses in criminal law: serious offenses, often called felonies, and less serious offenses, often called misdemeanors. Punishments for serious offenses may involve imprisonment for a term of several years to life and, in a few countries, the death penalty. 67. Lesser crimes are often punishable by no more than a fine. If a misdemeanor carries a prison sentence at all, that sentence is usually less than a year in length and is served in the local jail. The divisions between serious and lesser punishments and trial processes vary widely by country. 68. Within serious and non-serious crimes, penalties vary by the perceived severity of the crime. The U.S. categories, both state and federal, are typical, so they will serve as an example. The state categories align with the federal, so we will use the federal sentencing guidelines as a template. 69. In the United States, misdemeanors are commonly divided into three categories. Class A misdemeanor, punishable by a jail sentence of between 6 months and 1 year. Class B misdemeanor, punishable by a jail sentence of between 30 days and 6 months. Class C misdemeanor, punishable by a jail sentence of between 5 days and 30 days. Each level also carries a possible fine that can be imposed instead of or in addition to the sentence. In the United States, felonies, whether state or federal, are broken down into 5 categories: capital or Class A felony, punishable by life imprisonment or the death penalty; first degree or Class B felony, punishable by a prison sentence of 25 or more years; second degree or Class C felony, punishable by a prison sentence of between 10 and 25 years; degree or Class D felony, punishable by a prison sentence of between 5 and 10 years; fourth degree or Class E felony, punishable by a prison sentence of between 1 and 5 years. In all rule of law countries, including the United States, the government cannot enact any ex post facto laws. Ex post facto is Latin for after the fact. Thus, if something was not a crime when you did it, you cannot later be charged with a crime even if the government changes the law. For example, the posted speed limit on a road is 40 miles per hour. A camera captures you driving 40 miles per hour on Monday. On Wednesday, a new law is enacted that changes the speed limit to 25 miles per hour and is claimed to apply retroactively for the past month. This would be an ex post facto law. New laws can only apply prospectively to the future, not retroactively to the past. In rule-by-law systems, authoritarian governments often use ex post facto laws and the lack of habeas corpus to jail opponents and keep them in jail indefinitely. Defendants' rights and the burden of proof for guilt are similar in rule-of-law systems. In all rule-of-law countries, the burden of proof for a criminal offense is beyond a reasonable doubt. In the United States, because a criminal case can impact a person's liberty, the burden of proof is always on the government, and the standard of proof is always guilt beyond a reasonable doubt. In addition, every rule-of-law country has protections for individuals who are accused of crimes. 70. In the United States, individuals accused of crimes have several constitutional protections in criminal cases. Rights and liberties in the U.S. Constitution that apply to criminal proceedings. Art. I Sec. 9 CL 2 Right of habeas corpus. Art. I Sec. 9 CL 3 Art. I Sec. 10 CL 1 No ex post facto laws. Fourth Amendment right to be secure from unreasonable search and seizure. Fifth Amendment right to due process before deprivation of life, liberty, or property. Right to indictment by a grand jury when charged with capital crimes. Protection against self-incrimination. Sixth Amendment right to speedy trial by an impartial jury. Right to a defense attorney. Eighth Amendment protection against excessive bail, excessive fines, and cruel and unusual punishment. Table 11. 2 rights and liberties in the U.S. Constitution that apply to criminal proceedings. Rights upon arrest. In rule of law countries, police must advise you at the time of arrest of certain rights. These include the right to have an attorney assist you with your case and the right to be cautioned that anything you say can be used against you in court, what are referred to in the United States as Miranda rights. A Library of Congress report found that 108 countries, including civil law and common law legal systems, require something similar to the U.S. Miranda rights. 71. The European Convention on Human Rights and the Universal Declaration of Human Rights both contain similar provisions. When a person is arrested in the United States, the arresting officer must read them their Miranda rights, also called a Miranda warning, and advise them of their constitutional rights under the Fifth and Sixth Amendments to the U.S. Constitution. The text of the Miranda warning reads along the following lines: "You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Do you understand each of these rights as I have read them to you?" There are no magic, specific words police officers must say when informing a person of their Miranda rights, but the gist of the above must be included in a language the person under arrest understands. First, the person under arrest must be allowed to contact an attorney or, upon proving themselves financially unable to afford one, request that an attorney be appointed to them. Second, if the person under arrest wishes to remain silent, they must state that wish. If they speak other than for comfort or to request an attorney, they must re-invoke the right to remain silent. The right to remain silent applies only when an arrested person is being interrogated by police. It does not apply to forensic investigative work, and it does not preclude police officers from speaking in front of the person who is under arrest or trying to trick them into saying something. It only stops them from asking a direct question. Different rule of law countries have slightly different equivalents to the Miranda warning. The following table compares the US and UK versions of this warning. Warning: United States, United Kingdom. Right to remain silent at time of detention. You have the right to remain silent. Anything you say can be used against you in court. At the time of detention, you do not have to say anything. But it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Right to an attorney at time of detention. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. The custody officer at the police station must explain the arrested individual's rights. They have the right to receive free legal advice. Language check at time of detention. Do you understand each of these rights as I have read them to you? When the custody officer explains the individual's rights, the individual can ask for a notice in their language or an interpreter to explain the notice. Procedural warnings not required in the United States. Implied and determined on a case-by-case basis, the custody officer at the police station must explain that the individual has the rights to tell someone where they are, receive medical help if they need it, see the rules the police must follow, and see a written notice about their rights, e.g., regular breaks for food and to use the toilet. Table 11. 3. Comparison of U.S. and British arrest warnings. Search and seizure. Another way rule of law systems defend the rights of individuals is through protection against unreasonable searches and seizures. This means that law enforcement may perform reasonable searches and seizures, and much of the litigation in this area deals with the reasonableness of the search and seizure. The UN has created recommendations for best policing practices for all countries, including limiting the police's right to search an arrested individual's person, home, or belongings to this standard. 72. The recommended level of proof to warrant a search is probable cause that evidence of a crime will be found in the place to be searched. Probable cause is more than suspicion, but a lot less than guilt beyond a reasonable doubt. There is no exact definition of the term probable cause, and review is on a case-by-case basis. This protection in rule of law countries rests on recognizing a right to privacy and to be left alone by the police. 73. However, many countries do not follow these limitations. In those countries, the police can search a person's home and belongings or interrogate a person whenever they want to do so. 74. This is particularly true in rule by law countries. Writ of habeas corpus and the right to appear before the court. In all rule of law countries, a person held in jail has a right to demand to be brought before the court and told why they are being jailed. 75. In some countries, this process is referred to as a petition for a writ of habeas corpus. In rule of law countries, this right is not recognized. In those countries, a person can be held indefinitely, incommunicado, without any right to seek their freedom or to demand that the government prove the charges against them. In rule of law countries, the writ of habeas corpus process usually occurs automatically. Countries that adhere to the UN Charter on Human Rights follow these requirements. 76. The U.S. Constitution and state constitutions protect this automatic procedure, which is called arraignment. An arraignment is a type of court hearing held within 72 hours of arrest, at which an arrested individual is notified of the charges against them. In the United Kingdom, a person can be held for 24 to 96 hours before their first hearing, depending on the crime. 77. All rule of law countries have some limit on the time a person can be held in custody before appearing in court to hear the charges against them, and to have the court reiterate their rights to remain silent and to have an attorney. 78. At an arraignment in the United States, the arrested person is allowed to enter a plea, and the court sets bail. Bail is an amount of money to be paid or an agreement to restrictions on a person's freedom in exchange for release from jail while they are waiting for trial. Bail is not intended to be punitive. It is intended to ensure that the person being charged will appear for their court hearings and trial. 79. In the United States, if someone is charged with a misdemeanor, the case moves directly from the police to the prosecutor to investigate and prepare the case against that person. If the government wants to charge someone with a felony, they must receive the approval of a grand jury. A grand jury is a group of citizens who only hear evidence from the prosecutor and must determine whether probable cause exists to proceed with the charge and trial against the accused. If the grand jury decides there is probable cause, they issue an indictment, the formal charge for the crime. Note that the standard for a grand jury to issue the indictment is only probable cause, well below the standard of guilt beyond a reasonable doubt. Further, a defendant has no right to appear or defend themselves at the grand jury hearing, so it is a one-sided presentation of the evidence. Video. What to expect as a juror. Jury duty is a responsibility individuals have to their communities. What should you expect if you are called for jury duty? This short video explains. Capital punishment. The death penalty is a form of capital punishment. Capital crimes are those for which a person who is found guilty can be sentenced to the death penalty or to automatic life in prison without parole, depending on the laws in a specific country. A person can be found guilty of a capital crime even if the country does not have a death penalty. Some countries that still impose the death penalty can impose it for crimes other than murder and are permitted to impose it on juveniles. 80. These countries primarily include China and countries in the Middle East and Africa. A world map shows all of the countries that carried out executions between 2009 and 2020. Most countries did not carry out executions during this timeframe. Figure 11. 7 from 2009 to 2020, about 35 countries including the United States, Belarus, and several countries in Central Africa, the Middle East, and Asia, carried out executions. Source: Amnesty International. Attribution: Copyright Rice University, OpenStax under CC BY 40 license. Many countries, including all European countries with the exception of Belarus, have abolished the death penalty. 81. In these places, the maximum sentence is life in prison without parole. Show me the data. A bar graph shows the number of countries that have abolished the death penalty from 1991 to 2020. In 1991, almost 50 countries had abolished the death penalty. By 2020, more than 100 countries had done so. Figure 11. 8. Since 1991, the number of countries that have abolished the death penalty has more than doubled. Source: Amnesty International. Attribution: Copyright Rice University, OpenStax under CC BY 40 license. In the United States, many assert that the death penalty violates the U.S. Constitution's prohibition of the imposition of cruel and unusual punishments. In the United States in 1972, the procedures for execution being used in some states were found to violate the cruel and unusual standard. 82. Some states responded by changing their procedures and reinstating the death penalty. SCOTUS upheld those revisions as constitutional in 1976. 83. Other states decided not to reinstate the death penalty. 84. The federal government did not reinstate the death penalty for federal crimes until 1988 and has rarely imposed the death penalty or carried it out. 85. Since that time, more U.S. states have abolished the death penalty, making a total of 23 states, plus the District of Columbia, without the death penalty and 3 that are no longer carrying out executions. 86. A map of the United States shows which states have capital punishment and which do not. Alaska, Connecticut, Delaware, Hawaii, Illinois, Iowa, Maine, Maryland, Massachusetts, Michigan, Minnesota, New Hampshire, New Jersey, New Mexico, New York, North Dakota, Rhode Island, Vermont, Virginia, Washington, West Virginia, and Wisconsin do not have capital punishment as of August 2021. All other states do. Figure 11. 9. As of August 2021, 27 of 50 U.S. states had the death penalty, although 3 of those states, California, Oregon, and Pennsylvania, have imposed moratoriums on executions. 87. Source: National Conference of State Legislatures. Attribution: Copyright Rice University, OpenStax under CC BY 40 license. In the United States, only certain types of murder, such as premeditated murder for hire or murder of certain government officials, qualify as capital crimes. 88. In a few states, if someone is killed during the commission of a felony, anyone involved in committing that felony can be sentenced to the death penalty, even if they are not the one who committed the killing, under a principle called the law of the parties. Many oppose this imposition of the death penalty on someone other than the person who did the actual killing, and state legislatures are reviewing the situation. 89. In the United States, even states that impose the death penalty cannot impose it on an individual who is under 18 or mentally disabled at the time of the crime. 90. The harshest sentence a juvenile can receive in the United States is life in prison without parole. Even in those states that use the death penalty, it is being applied less often. Show me the data. A bar graph shows how new death sentences in the United States have decreased from close to 300 in 1988 to fewer than 100 in 2018. Figure 11. 10. In the 30-year period from 1988 to 2018, new death sentences in the United States decreased from close to 300 in 1988 to less than 50 in 2018, a reduction of more than 80%. Source: Death Penalty Information Center. Attribution: Copyright Rice University, OpenStax under CC BY 40 license. The federal death penalty applies in all 50 states and U.S. territories, but is used relatively infrequently. As of November 2021, there were 45 federal prisoners on death row. 91 no federal government executions occurred after 2003 until 2020, when President Donald Trump ordered federal officials to begin carrying out executions. During the remainder of his presidency, 13 federal prisoners were executed. 92. Show me the data. A pie chart shows the race of federal death row prisoners in the United States as of November 2021. 20 black prisoners, 17 white prisoners, 7 Latino prisoners, and 1 Asian prisoner. Figure 11. 11. As of November 2021, there were 45 inmates on federal death row in the United States. Source: Death Penalty Information Center. Attribution: Copyright Rice University, OpenStax under CC BY 40 license. At the end of 2018, 2,567 prisoners were on death row in U.S. states. From 1977 to 2018, 34 states carried out 1,490 executions. Texas carried out 37% of those executions. While California has the most people on death row, it has not carried out any executions for many years. Since March 2019, when Governor Gavin Newsom placed a stoppage on executions, all death row inmates in California have effectively been serving life sentences. 93. For more information about the death penalty and executions in the United States since 1978, visit USA Facts, where you can explore interactive graphics that provide comparative data showing how each state and the federal government has applied the death penalty. The split internationally and between the states on support for or opposition to the death penalty reflects the general division in society over whether or not the death penalty is intrinsically cruel and unusual under current human rights standards. 94. The U.S. Supreme Court has held that the meaning of cruel and unusual rests on society's evolving standard of decency, and thus there is no set standard. 95. As society's view of the death penalty changes, so can the application of the concept of cruel and unusual punishment. Those who oppose the death penalty 96 make a number of different arguments. Some argue that life without parole meets the purposes of criminal punishment better than execution. They say that a life without parole permanently removes from society the person who has been sentenced just as much as the death penalty would. Thus, the standard of incapacitation of the person to commit another crime is met. 97. Some argue that because investigations have found that some people executed or placed on death row are innocent, injustice cannot be corrected if the death penalty is carried out. 98. Killing someone for the crime of killing has been held up as state hypocrisy. Additionally, there are questions about the equal application of justice in death penalty cases, because racial minority defendants tend to receive the death penalty more often than white defendants who are convicted of committing the same or similar crimes. 99. Further, the race of the victim is a factor. A 1990 U.S. government report states that in 82% of the studies reviewed, race of victim was found to influence the likelihood of being charged with capital murder or receiving the death penalty, i.e., those who murdered whites were found to be more likely to be sentenced to death than those who murdered blacks. 100. Show me the data. Two pie charts show how race relates to the death penalty in the United States since 1976. The pie chart on the left shows executions by race of the defendant in the United States since 1976. 856 defendants were white, 129 defendants were Latino, 524 defendants were black, and 25 defendants were other races. The second pie chart shows executions by race of the victims in the United States since 1976. 1,158 victims were white, 100 victims were Latino, 205 victims were black, and 76 victims were other races. Figure 11. 12. Historically in the United States, more than twice as many black defendants have been executed as have defendants in cases in which the victim was black. Source: Death Penalty Information Center. Attribution: Copyright Rice University, OpenStax, under CC by 40 license. Civil law. Civil law is everything that is not criminal law. Thus, it is wide-ranging and complex, covering everything from family matters, marriage, divorce, adoption, guardianship, probate, etc., to personal injury, workers' compensation, medical malpractice, and business disputes. Civil law differs from criminal law in that individuals or groups file cases rather than the state. The legislature enacts laws that establish standards of conduct and recognizes relationships. The legislature will establish the duty owed and rights between individuals, what constitutes a breach, and what damages may be recovered for that breach. Because civil law topics are so wide-ranging, the burden of proof for the complaining party similarly varies. It can range from merely a preponderance of evidence to clear and convincing evidence. Civil law, criminal law. Definitions: laws concerned with interpersonal disputes such as divorce, debt, personal injury, statutes that identify conduct as criminal felonies or misdemeanors. Punishable by the government. Cases filed by individuals, the government. Type of punishment: monetary damages, disposition of property and/or a relationship, incarceration, fines. Probation. Burden of proof ranges from a preponderance of evidence to clear and convincing evidence. Depending on the topic, always guilt beyond a reasonable doubt. Appeals filed by any dissatisfied party, the defendant. Right to a jury: must pay a fee to have a jury, automatic in some cases, requested in others. No fee charged. Jury verdict does not always have to be unanimous, must be unanimous. Table 11, for a comparison of civil law and criminal law. Learning outcomes. By the end of this section, you will be able to describe the elements of due process, discuss the need for fairness in a judicial system, discuss the hierarchy of courts, discuss the different types of courts and their operations. Due process is the legal requirement that the government must respect the rights of the accused and take procedural steps to create a fair system of government action against the accused. The concept of due process appeared as far back as the Magna Carta, which held that no noble could be deprived of liberty or property without due process in a hearing before their peers. 101. The Universal Declaration of Human Rights protects people's right to due process before a government can take action against them. 102. The European Convention on Human Rights provides for due process of law by a fair and impartial hearing before the government. 103. As discussed in Chapter 4, Civil Liberties, there are two due process clauses in the U.S. Constitution, one in the Fifth Amendment which applies to the federal government and one in the 14th Amendment which applies to the states. Other than the entities to which they apply, both clauses are identical. The clauses provide that no person shall be deprived of life, liberty, or property without due process of law. 104. And nor shall any state deprive any person of life, liberty, or property without due process of law. 105 respectively. They apply to all persons, not just citizens of the United States. All rule of law systems have similar due process requirements. To understand the application of due process, one must first ask what procedures are due and what deprivation of life, liberty, or property means. There are two types of due process, procedural and substantive. Procedural due process is the steps the government must take before depriving an individual of life, liberty, or property. The U.S. Supreme Court has held that procedural due process at a minimum requires 1. Notice, 2. An opportunity to be heard, and 3. An impartial tribunal. 106. When determining if a process is constitutional, courts consider 1. The nature of the right at issue, 2. The adequacy of the procedure compared to other procedures, and 3. The burdens other procedures would impose on the state. 107. These procedures can be seen in criminal and civil cases where special rules of procedure and evidence apply. These will be discussed in greater detail when the trial process is explored. Due process that attempts to ensure that the system of laws and courts is fair to all persons is substantive due process. Substantive due process applies the protections of individual rights under the Constitution and measures the activities of government to determine if they treat each person fairly and equally, without infringing on those constitutional rights. As the image of Lady Justice that opens this chapter shows, the scales of justice need to be in balance, and justice must be blind so that everyone is equal in the eyes of the law. When reviewing how fair a system is, it is important to consider to what degree the judge and jury are impartial. One way of looking at judicial impartiality is to examine judicial independence. If the judiciary is not independent of influence, people will not believe it is fair or impartial. You learned about some of these issues in the discussion of judicial selection. There is a high degree of concern about judicial impartiality in some countries because the judiciary in those countries is not independent of other branches of government or oversight by religious leaders. In China, the Chinese Communist Party controls all government offices, including the judiciary. Thus, it is rare for the judiciary to overrule any government action. The Iranian constitution states that the judiciary upholds Islamic law. Thus, it is restricted in reviewing government actions against citizens. Further, the judiciary is under the supreme leader and guardian council, religious figures who can overrule the court's actions at will. 108. How independent of pressure from the executive can these Supreme Court justices feel when reviewing government actions against individuals? In the United States, the president nominates judges to the federal courts. The Senate then reviews these nominations and may confirm or deny them. Federal judges are appointed for life, regardless of who the next president may be. The judiciary is thus said to be independent and neutral of political forces. How impartial and independent it really is remains in question, as presidents tend to nominate persons with political views similar to their own. Even after attaining office, an individual judge may continue to decide cases in keeping with those political views. Further, how equally are people treated under the same law? For example, there are long-standing concerns in the United States about how fairly the criminal justice system treats racial minorities. Unfortunately, this issue is not limited to the United States but is a problem around the world. It is one that the UN continually works to remedy. 109. In rule-of-law countries, the standard style of court system is a three-tier hierarchy, although the names of the parts and what they can do vary widely by country. A flow chart shows the structure and hierarchy of the court system in the United States. At the lowest level are the trials courts. If a case is appealed, it may be considered by an intermediate court of appeals. Finally, a case might end up being seen by the highest court. Figure 11. 13 In the United States, trial courts are subordinate to intermediate courts of appeals, which are subordinate to the highest courts. Attribution. Copyright Rice University, OpenStax, under CC BY 40 license. In the U.S. Article III federal court system, there are 94 district courts, which are trial courts organized into 12 circuits or regions. 110 Each circuit has its own court of appeals that reviews cases decided by district courts within the circuit. The U.S. Court of Appeals for the Federal Circuit hears cases of a particular type from across the nation. There are two levels of appeal in the United States: the Intermediate Court of Appeals and the Supreme Court of the United States. Each state has its own court system, but all states use the three-tier hierarchy. The names of the courts vary as well as the types of cases they hear. Trial courts. Trial courts are the first level of courts in any system. The common characteristic of trial courts worldwide is that they are courts of original jurisdiction, the first courts with authority to hear a case. The exact process for a trial varies widely by country. In the United States, trial courts are bound by strict procedures and evidence designed to ensure due process. 111 After judgment in a U.S. trial court, the final decision of the case is written down in a document called an order or judgment that an aggrieved party might use to appeal a case to a higher court. The basic trial court process in the United States is as follows. 112. Filing of complaint and pretrial documents. All cases rest on written pleadings of the parties asserting claims or defenses. In these documents, the specific questions of the case are detailed. Matters that are not mentioned in the pleadings cannot be brought up during the case. Pretrial discovery. This occurs during the investigative stage. The parties seek evidence to support their positions. The evidence must be in a form that can be admitted in court. There are strict rules of evidence. Not everything is admissible. The trial. There are several stages to the actual trial. Voir dire. In this stage, the people who have been called for jury duty are questioned to see if they have any prior knowledge or biases that would prevent them from being eligible to sit on the jury for a specific case. Opening statements. The attorneys give synopses of what they hope to prove with the evidence. The jury listens to these synopses but cannot use them in making their decision. Evidence. During this stage, testimony and documents are formally presented in the court. Strict rules ensure truthfulness, the accuracy of the evidence, and that only information related to the questions in the case is presented to the jury. The jury may only rely on the evidence presented in court when making their decision. Each side has an opportunity to call and question any witness. The attorney calling the witness conducts direct examination, asking questions that support their view of the case. The opposing attorney can then cross-examine the witness in an attempt to elicit information supporting their perspective or to discredit the witness's testimony so that the jury may question whether it is reliable. Closing statements. Each attorney summarizes their case and tries to convince the jury that the evidence presented supports their conclusion. The jury listens to the closing statements, but they are not supposed to rely on them in making their decision. Verdict. The jury is given specific questions to answer. They can only answer these questions. Their answer is the verdict or decision in the case. Judgment. Judgment is the formal legal acceptance of the decision in the case. The judgment is the document used to enforce the decision on the parties. Video. How a trial works. Criminal and civil common law trials are adversary in nature. Ideally, the combined arguments of the prosecution and the defense, with the judge's moderation, reveal something close to the truth in a case. The prosecution and the defense focus on the facts of the case, while the judge focuses on proper procedure and the substance of the law. In a civil case, any party dissatisfied with the judgment can request an appeal, and in a criminal case, a defendant who is found guilty can request an appeal. The government cannot appeal in a criminal case if the defendant is found not guilty due to the U.S. Constitution's prohibition against double jeopardy. All rule of law countries recognize some form of double jeopardy. The U.S. Constitution provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. 113 This means that if a person is acquitted or found not guilty, they cannot be tried again for the same offense at a criminal trial. They can, however, be tried for another offense or in another jurisdiction. For example, if you rob a bank and shoot someone as you are getting away, you have violated both federal and state statutes and can be charged and tried separately by each jurisdiction for the offenses. In this example, you can be charged with and tried for at least 2 federal and 2 state charges. Many people mistakenly think this is double jeopardy, but double jeopardy only applies when a person is found not guilty of a crime and then tried again in the same jurisdiction for the same crime. In the above example, if the federal government tried you for bank robbery and you were acquitted, the state could still try you for bank robbery, but the federal government could not try you a second time for that crime. Appellate courts. An appeal is a higher court's review of a lower court's decision. The workings of the appeals process vary widely around the world. In the United States, an appeal serves only to determine if an error of law occurred in the lower court that may have resulted in the rendition of an improper judgment. An appeal is not a do-over of the original trial. There are strict standards for reviewing the lower court's action, which vary by type of case. 114. 5 judges sit at the bench at the front of a courtroom. A man speaks from a podium in front of the judges. Additional people sit at tables on either side of the podium and in rows of chairs behind the tables. Figure 11. 14. This photo was taken inside a court of appeals in Annapolis, Maryland. Credit: Chief Judge Robert Bell's portrait unveiling at the Court of Appeals by Maryland Gov Pics/Flickr, CC by 2. 0. No witnesses are called during an appeal, no new evidence is taken, and there is no jury. A panel of judges reviews the written record of the lower court proceeding and compares this to the written law being applied. In judicial review systems, the appellate panel of judges also looks at the precedent of similar cases. Relying on this review of the lower court's proceeding, the law, and, if applicable, the precedent, the judge determines if the lower court made a substantive legal error. If they do not find there was a significant error, they affirm the lower court's judgment. If they find an error, they reverse the case. When they reverse, they can order one of 2 things: remand or rendition. In reverse and remand, the court instructs the lower court on correcting the error and sends the case back for a new trial. In the rare instances of reverse and render, the court finds that the error was so serious that they need to enter the correct judgment, and there are no further proceedings in the trial court. 115. If a case is before an intermediate court of appeals and one of the parties is dissatisfied with the decision, the parties can request that the highest court review the case. SCOTUS is the highest court in the U.S. system. It can hear cases from lower federal courts or from a state's highest court if an issue involving the U.S. Constitution has been raised. SCOTUS is not required to hear any appeal. Instead, they hear cases at their discretion, which is called a writ of certiorari. Thousands of cases from around the country are filed with the court each year, of which they hear and decide less than 100. 116. Thus, the Supreme Court carefully selects its cases to address major issues concerning the entire nation. The people pay close attention to the court's decisions because many of these cases involve important political issues of the day. Once the highest court decides, the case is final and the judicial review system's decision becomes precedent. Other countries have similar hierarchical systems. The exact jurisdictions and names of the courts may differ, but the hierarchical style of trial and review applies. A major difference between the countries is whether or not they use judicial review or recognize parliamentary sovereignty. Learning outcomes. By the end of this section, you will be able to define judicial review, discuss restraints on judicial review, explain who and what is subject to judicial review, explain executive sovereignty, explain who and what is subject to executive sovereignty. Judicial review is one means of checking to see whether the other branches are following a country's constitution and its principles. In some countries, this review is conducted not by the judicial courts but by a group that reviews proposed laws while the legislature is still debating them. For example, in France, the Constitutional Council reviews all acts of Parliament before they are enacted to ensure that they do not violate the French Constitution. 117. If the Council finds that a proposal does violate the Constitution, Parliament can correct it before enacting the law. In the United States, the courts perform judicial review. 118. The U.S. Constitution, not a branch of government or an individual, is the supreme law of the United States. The power of judicial review includes the power to make sure that all branches of government at all levels comply with the U.S. Constitution. Even though judicial review exists in the United States, all laws and government actions that come before the court enjoy a presumption of constitutionality. The amount of deference to that constitutionality varies with the type of action and the judge. For example, since World War II, individual and civil rights have been broadened, and courts have been less deferential to government actions restricting personal liberty. Still, courts rarely hold that an act is unconstitutional. 119 as of 2014, out of the millions of actions Congress and the President have taken in the history of the United States, SCOTUS had only ever held 176 acts of Congress to be unconstitutional. 120 Another myth about judicial review is that SCOTUS frequently finds actions of the other branches of state governments unconstitutional. More state laws have been struck, but the percentage is still meager, given that the 50 states take millions of actions each year. Most of the state laws the court has struck since 1960 have involved civil rights, with only 483 state laws declared unconstitutional as of 2019. 121 Using judicial review, the courts check all government actions against the Constitution and ensure that it is the supreme law of the land. In a parliamentary sovereignty system, this check is not available. In an executive sovereignty system, a parliamentary sovereignty system, or a legislative sovereignty system, the courts cannot overrule executive or parliamentary action through judicial review. In executive, parliamentary, or legislative supremacy systems, the legislative body is supreme over all other government institutions. The legislature may change or repeal any law and, in some countries, is not bound by case precedent or a constitution. The United Kingdom is an example of a country with parliamentary sovereignty. In the UK, the monarch initially was all-powerful and could do anything they wanted. Even after a royal parliament had been in place for many years, the monarch retained near-total power and could dissolve the parliament. After the English Civil Wars, Parliament became all-powerful, and since that time the monarch's role has been largely ceremonial. In the era of parliamentary preeminence, the Houses of Parliament, the House of Commons and the House of Lords, under the unwritten constitutional principles of the UK, hold the right to make or repeal any law. No one can override a parliamentary act. Parliament can make or change any law. Video. UK Supreme Court rules prorogation unlawful. In 2019, the UK Supreme Court ruled that Prime Minister Boris Johnson acted unlawfully when he stopped the work of Parliament during Brexit debates. Furthermore, an act of Parliament cannot be challenged in court as unconstitutional, as Parliament is the supreme lawmaker. However, since World War II, the British Parliament's power has been curtailed in some measure by new laws and agreements to be bound by international treaties. Nevertheless, Parliament retains the ability to repeal these laws or consent to any of these international agreements. 122. Brexit, the recent parliamentary vote and referendum of the people of the UK to leave the European Union (EU), which had bound the British courts to follow specific economic laws and policies effective throughout Europe, provides a prime example of such a repeal. While the parliaments that joined and stayed with the EU bound themselves temporarily to international agreements, a later parliament retained the right to undo the binding and reassert supremacy. Any check on the British Parliament rests in the public perception of and support for the government. If the public loses confidence in Parliament, elections can be called, and new members who agree to vote in line with public sentiment can be voted into office.